country was an active collaborator and has always been a strong supporter of the Convention, of which it is a party for almost 70 years. Prevention and punishment of genocide are the object and purpose of the Convention. However, Ukraine is not accusing Russia of committing genocide. Ukraine is also not accusing Russia of failing to prevent or punish genocide. On the contrary, Ukraine insists no genocide has occurred. That alone should be enough to reject the case, because, according to the court's jurisprudence, if there was no genocide, there cannot be a violation of the Genocide Convention. What Ukraine complains about is Russia allegedly abusing the Genocide Convention as a pretext for recognizing the independence of Donetsk and Lugansk People's Republic and conducting the special military operation. It cannot be further from the truth. Firstly, it is a well-known fact that Russia launched the SMO under Article 51 of the UN Charter, which provides the right of individual and collective self-defense. This right is not affected at all by the Genocide Convention. Secondly, in order to complain about the abuse of right, one must first establish such right. Ukraine seems to claim that the Genocide Convention provides some kind of right to use force, which Russia allegedly abused. But the Convention, of course, provides no such right. Nor has Russia ever claimed it does. The pretext that Ukraine uses to drag this case into the courts is apparently Russia's officials using the word genocide when describing what Ukraine's forces have been doing with the people of Donbass for the past 9 years, ever since the current Russophobic neo-Nazi regime came to power in Kyiv by violently overthrowing the constitutionally elected president of Ukraine in 2014. However, making statements regarding genocide cannot be illegal under international law, including the Genocide Convention. The statements are unsurprising, given the fact that Kyiv launched in 2014 a full-scale war against Donbass. Its policy to brutally quash any dissent, obstruct journalists, and promote hatred against ethnic Russians. The current Kyiv regime glorifies Nazi war criminals, adopts Nazi symbolism, and does not ban neo-Nazi groups. At the same time, Kyiv bans education of the Russian language and pushing the Russian language out of all spheres of public life. Russian books, films, and Russian artists are banned. Russian Orthodox churches are violently seized by Ukrainian security forces and neo-Nazi militants. The predominantly Russian people that lived in the southern and eastern Ukraine strongly opposed the 2014 coup new neo-Nazi policy. In response, Kyiv imposed a suffocating blockade on Donbass, robbing their populations of access to water, food, electricity, medicine, and other critical goods, and launched the so-called anti-terrorist operation, deploying military force against its own population, igniting a civil war. Russia tried to peacefully resolve the civil war in Ukraine. Russia actively participated in Normandy format negotiations and trilateral contact group to develop solution for Ukrainian crisis. It was the Russian president who first proposed to deploy UN peacekeeping units in Donbass. Ukraine impeded that initiative. Nevertheless, Russia's efforts brought results. I'm talking about conclusion of the Minsk Protocol dated 5th September 2014 and Minsk II agreement dated 12 February 2015. These are the only agreements concluded in relation to Ukraine's crisis. More than that, Minsk II was endorsed by the UN Security Council resolution. The Minsk agreements provided for ceasefire, ban on heavy weaponry and drones, amnesty for participants to the conflict. Importantly, the agreements envisaged the reintegration of the DPR and LPR into Ukraine on the condition of a constitutional reform in Ukraine and providing DPR and LPR greater autonomy. However, neither Ukraine nor its Western handlers ever intended to fulfill these UN-approved agreements. Today, all of them, Ukraine's President Poroshenko and Zelensky, Germany's former Chancellor Merkel, France's former President Hollande, proudly declared that Ukraine was never expected to implement the Minsk agreements. Instead, the agreements were supposed to give Ukraine breathing space and time to beef up its military power. In another case before the court, Russia had already emphasized that even the majority of the people of Ukraine wanted the Donbas conflict to be resolved by peaceful means. But nobody in the Ukrainian government heard those voices. President Zelensky cynically exploited the peaceful aspirations of people in eastern Ukraine during his election campaign, promising here Donbas and stop the shooting. However, the Kyiv regime once again defeated its people. The violence never stopped, and Ukrainian officials openly mocked a military solution for the Donbas problem. For instance, Ukrainian Deputy Prime Minister Alexei Reznikov, in charge of so-called reintegration of temporarily occupied territories, called Donbas a mentally ill territory and a cancerous tumor that could be cut out. Reznikov was not fired for these words. On the contrary, he soon became the Ukrainian Minister of Defense. Talking about how Ukraine would deal with Donbas, Reznikov gushed about Croatia 1995, Operation Storm and Operation Lightning, which led to the complete expulsion of the Serbian population from this Balkan Republic. While planning Operation Storm, Croatian President Tudjman had said, "We have to inflict such blows that the Serbs will, to all practical purposes, disappear. And if we had enough ammunition, then I too would be in favor of destroying everything by shelling prior to advancing." When examining Serbia's counterclaim against Croatia under the Genocide Convention, the court had concluded that there had been ethnic cleansing on massive scale. Serbian civilians were arbitrarily killed by Croat forces and driven from their lands. Reznikov called these operations successful and said they ensured military reintegration. It's easy to see how Kyiv intended to deal with Russians from Donbas once it secured total control over the region. With the foreign aid, Ukraine built up its military capacity and kept bombing Donbas in violation of the Minsk agreements, all the while preparing for the final solution of the Donbas problem by force. By 2022, the conflict in Donbas had been ongoing for 8 years, with hundreds of thousands of ceasefire violations every year and a constant flow of hundreds of civilian casualties. By far, the most of the civilians were killed or injured by Ukrainian strikes on the DPR and LPR territory. In 2021, the number of ceasefire violations increased by more than 300% in comparison to 2020. As usual, the vast majority of strikes came from the Ukrainian side, with more than 75% of civilian casualties as a result of these attacks being reported in the DPR and LPR. Finally, in February 2022, the violence in Donbas spiked, As Ukrainian forces stepped up their attacks, nearly 2,000 ceasefire violations were recorded by the OSCE in a single day on the 21st February, including over 1,000 artillery and bomb strikes. Ukraine's single-minded drive to take Donbass by force overturned 8 years of diplomacy and negotiations. In a last bid to bring sense to warmongers in Kyiv, on 21st February, the Russian Federation has recognized the independence of DPR and LPR. However, this also failed to cool down Ukraine's desire to resolve the conflict through force of arms. The tempo attacks persisted on 22 February with almost 1,500 explosions along the contact line. It is in these circumstances that the Russian Federation, on 24 February 2022, took the decision to commence a special military operation. The President of the Russian Federation, in his publicly broadcasted speech on that day, explained the reasons underlying that decisions. First, the President expressly referred to Article 1 of the UN Charter and the principle of self-determination of peoples. Second, the President expressly referred to Article 51 of the UN Charter and the inherent right of a state to self-defense. Third, the President recalled the growing threat of NATO expansions into the territory of Ukraine and the futility of efforts to reach an agreement with NATO regarding equal and indivisible security in Europe. Fourth, the President referred to Russia's treaties on friendship with DPR and LPR and to the Republic's appeal to Russia for military assistance and self-defense under those treaties. And finally, the President also referred to Ukraine's violations of the UN Security Council Resolution 2202 upholding Minsk agreements. The reference to Article 51 of the Charter as the legal basis for the special military operation has been reiterated on this very same day by Russia's representative to the United Nations in his speech before the Security Council and the General Assembly, as well as in a letter to the Security Council and the United Nations Secretary General as a formal notification required under Article 51 of the Charter. None of these speeches or documents which express the official position of the Russian Federation contained references to the Genocide Convention. As to expressions of concern regarding the threat of genocide, as I said, they were unsurprising considering the policies of Kyiv regime, which was firmly entrenched in the history, doctrines, and practices of Nazism. The Nazi roots of the Kyiv regime come from the Organization of Ukrainian Nationalists, AUN, and its military wing, the Ukrainian Insurgent Army, UPA, which collaborated with the Nazis and took part in the massacre of hundreds of thousands of Jews, Poles, and Russians. These three are the founding fathers of Ukrainian Nazism. At the center is Stepan Bandera. He led the most radical faction of OUN, the OUN-B. OUN believed that the alliance with Nazi Germany and its Führer Adolf Hitler was necessary to achieve this goal. Now you see the Ukrainian newspaper dated 31st July 1941. Publishing the Act of Proclamation of the Ukrainian State signed by Bandera. It said that the newly created Ukrainian state will work closely with National Socialist Germany, which under the guidance of its leader Adolf Hitler is creating a new order in Europe. The photo on the right is Roman Shukhevich, commander of the notorious punitive battalion Ukrainische Sondergruppe Nachtigall. Two of the most heinous crimes in which the followers of Bandera and Shukhevich were involved, the Volyn massacre and Babi Yar massacre. In all, more than 5.3 million people died in Ukraine at the hands of the Nazis and their henchmen. Bandera and Shukhevich are both venerated by the current Kyiv regime. Here you see Bandera's monuments in Lvov, Ivano-Frankovsk, and Ternopil. Now see Shukhevich monuments in Lvov. The leader of the second OUN faction, OUN M, was Andrei Melnik. Here you see the archival photo from 1941 taken in Western Ukraine. On the arch hangs a poster, "Long live Hitler, long live Melnik." On the right is a modern monument to Melnik in Ivano-Frankovsk, Western Ukraine. The Kyiv regime's own ideologists have admitted that OUN-UPA was a typical Nazi organization. On the next slide, you can see a Nazi march in Dan Stanislavov, now Ivano-Frankovsk, Western Ukraine, 1941, and the march celebrating the 71st anniversary of SS Galiciana Division founding Lvov, Western Ukraine. In early 1990s, OUN was legalized in Ukraine under the new title, Congress of Ukrainian Nationalists. Yuri Shukhevich, son of Roman Shukhevich, established and led another Ukrainian major neo-Nazi party, the Ukrainian National Assembly, UNA-UNSO. From these odious roots stemmed nowadays neo-Nazi movements in Ukraine, such as Svoboda, Trizub, Right Sector, Sich, and many others. You see a 2008 Congress of the Patriot of Ukraine movement in Kharkov. The speaker is Andrei Beletsky, the future founder of the infamous neo-Nazi battalion Azov. The Patriot of Ukraine's official logo was the Nazi German Volksangel, which you can see on the banners. The same Volkshook can be observed on the Tiger tank of the Nazi SS Totenkopf division. The resurgence of neo-Nazi in Ukraine did not go unnoticed in the world. In 2008, the Jewish Telegraphic Agency published the alarming report on the widespread use of Nazi symbols and Nazi salutes in neo-Nazi mass events across Ukraine. These neo-Nazi groups became the driving force behind the violent coup d'etat, where armed neo-Nazi fighters overthrew the legitimate Ukrainian authorities and formed an illegitimate new government of victors, where a key position had been taken by neo-Nazi extremists. Here, the Svoboda neo-Nazi party members who joined the new government, shown with Svoboda's symbol, the Nazi Volksangel cross. Same background of these neo-Nazis available on the next 4 slides. This Ukrainian government glorifies the collaborators who fought on the side of Hitler during the Second World War. Those who are still alive are granted with veteran status, state protection, and benefits. More than 200 streets across Ukraine have been named after Nazi criminals. On the next slide, you can see the SS Galiciana division being honored in Kyiv. Neo-Nazi summer camps for children were opened all over Ukraine, indoctrinating children with the ideas of Bandera and hatred of Russians. Now, behold President Zelensky naming a Ukrainian mountain brigade Edelweiss after the Nazi mountain division of the same name. Finally, here is a modern German Leopard tank of the Ukrainian armed forces, proudly bearing the notorious Nazi Balkan Kreuz, the white cross marking carried by Nazi army during their campaign in Poland and in the USSR. On the international field, since 2014, Ukraine has been steadily voting against the UN's General Assembly annual resolution on combating glorification of Nazism, neo-Nazism, and other practices that contribute to fueling contemporary forms of racism, racial discrimination, xenophobia, and related intolerance. Madam President, in its order on provisional measures, the court found that Ukraine has a plausible right not to be subjected to military operations by the Russian Federation for the purpose of preventing and punishing an alleged genocide in the territory of Ukraine. However, that decision is preliminary in nature. When the court will decide on the jurisdiction of the case, it should bear in mind that this finding is not consistent with the court's previous finding in the legality of use of force cases. Back then, the court discarded Yugoslavia's request for provisional measures, despite Yugoslavia being the victim of an intensive bombing campaign by NATO forces. Numerous NATO leaders had referred to genocide as the legal basis for the operation. Representatives of NATO states have repeatedly stated so before this court. Just last year, Germany's Chancellor, Mr. Scholz, confirmed this in his dialogue with President Putin, in Yugoslavia because, I quote, there was a danger and a threat of genocide, and these ought to have been prevented. NATO states had no other justification for their attack. They never invoked Article 51 of the UN Charter, nor did they have any ground to do so. No genocide was established to take place in Kosovo. Madam President, members of the court, according to this jurisprudence of the court, no jurisdiction can be awarded to Ukraine's claims. Deciding otherwise would be effectively a reversal of the position that the court took with regard to Yugoslavia's plea. Of course, Russia has always condemned the bombing of Yugoslavia by NATO and rejected NATO's attempts at justification. This confirms that Russia never believed that genocide convention to provide a legal basis for armed interventions. Ukraine's attempt to use an unrelated treaty in order to bring claims related to use of force and state recognition to the court, despite absence of jurisdiction, is nothing new. Back in 2008, another country, Georgia, much like Ukraine, attempted to re-establish control over two breakaway regions, Abkhazia and South Ossetia, by force, violating, like Ukraine, a UN-endorsed peace agreement, and even attacking Russian peacekeepers present on the international mandate. Georgia, like Ukraine, attempted to mask the real nature of its dispute with Russia and drag the court into adjudicating use of force by window dressing its claims as falling under the treaty with a compromissory clause, in that case, the SERD. Back in 2011, the court has correctly decided that Georgia's claims rooted in the allegations of use of force did not pertain to racial discrimination. Summing up, Ukraine's legal position is hopelessly flawed and at odds with the long-standing jurisprudence of this court. Our legal arguments to this effect will be developed in more detail by our counselors. Madam President, Professor Hadi Azari will present Russia's first preliminary objection, namely that there is no dispute between Ukraine and Russia under the Genocide Convention. After that, Professor Alfredo Cruzado-Newman will continue with the second objection on the lack of the court's jurisdiction, razione materia in this case. Professor Sin Hoyi will explain Russia's third objection on the inadmissibility of new claims that Ukraine inappropriately advanced in its memorial, And the fourth objection on the lack of a fair utile of the prospective judgment upholding Ukraine's claims in this case. Mr. Kirill Udovichenko will further demonstrate Russia's fifth objection, that Ukraine's claims seek reverse compliance declaration and are therefore inadmissible. And will complete the presentation with the point that is clear to everyone in this hall, that Ukraine's claim in itself and its tactics in these proceedings is a manifest disregard of the proper administration of justice and constitutes an abuse of process. I thank you, Madam President, honourable members of the Court, for your attention. I now kindly ask you, Madam President, to invite Professor Hadi Azari to address the Court.
I thank the agent of the Russian Federation for his statement, and I now invite Professor Hadi Azari to take the floor. You have the floor, Professor.
Merci beaucoup, Madame la Présidente.
Thank you very much, Madam President. Members of the Court, it is a great honor for me to appear once again before the Court to present the first preliminary objection of the Russian Federation, in this case against Ukraine. My task is to demonstrate that there is no dispute under the 1948 Convention on Genocide, which should lead the Court to decline its jurisdiction to entertain Ukraine's claims. The conditions of the existence of a dispute are very clearly specified in the Court's jurisprudence, and I will summarize these in a few lines. For a dispute to exist, the Court must establish, based on evidence provided by the parties, that on the date of filing the application, the applicant made a claim that was positively opposed by the respondent. The claims made by UK do not meet these conditions. In its first conclusion, Ukraine claims that there is no credible evidence that Ukraine is indeed responsible for committing genocide in violation of the Genocide Convention. This claim made by Ukraine is based on the supposed allegation of genocide that Russian Federation allegedly made against it. And to establish this, Ukraine has to prove that it has violated, first of all, the 1948 Convention that Russian Federation made against it, and secondly, that this claim was positively opposed by the Russian Federation, and three, the disagreement existed on the date when the application was filed. Ukraine has been unable to demonstrate this. Firstly, Ukraine should have specified its allegation before instituting proceedings. In Georgia versus the Russian Federation, the court stated that the applicant, and I quote, must refer to the subject matter of the treaty with sufficient clarity to enable the state against which a claim is made to identify that there is or may be a dispute with regard to that subject matter. An express specification would remove any doubt about one state's understanding of the subject matter in issue and put the other on notice. End of quote. A dispute cannot exist between Ukraine and the Russian Federation under provisions of the 1948 Convention. Therefore, as to the purported allegation of genocide, Ukraine must identify the obligations stemming from this convention, which, according to it, Russia has allegedly violated. Needless to say that a dispute cannot originate from an obligation that doesn't exist. Ukraine must prove that the convention bans states from making allegations of genocide against each other. Ukraine has failed to meet this criterion. And this is hardly surprising because such an obligation simply doesn't exist, and a dispute cannot originate from an obligation that doesn't exist. In fact, this is the reason why, in the different formulations of the dispute submitted to the court, Ukraine does not rely on any provision of the convention to support this claim, contrary to what it has done for the other two claims. As you can see on the screen, the parts that are highlighted. Bringing up the Gambia versus Myanmar case is of no help to Ukraine, to the extent that in the court's judgment of 22nd of July 2022, the court did not dismiss the arguments supported by the Russian Federation. On the contrary, it confirmed them. The applicant states the court says, must refer to the subject matter of the treaty with sufficient clarity to enable the state against which a claim is made to identify that there is or may be a dispute with regard to that subject matter. End of quote. No claim was made by Ukraine that Russia had allegedly violated the 1948 Convention before filing its application. There was no evidence at all that was presented to the court demonstrating such a claim made by Ukraine against Russia. There is no note verbal addressed by Ukraine to the Russian Federation in which Ukraine exposes its opinions as to the fact that Russia's conduct was supposedly in breach of the convention. No claim similar to what Ukraine has presented in its application or its memorial was made against Russia before instituting the current proceedings. There is nothing at all in Ukraine's submissions demonstrating that it had informed Russia that it considered the accusation of genocide as being counter to Russia's obligation under the Genocide Convention. However, the court's established jurisprudence is unambiguous in this respect. It requires that the applicant should inform the respondent of its accusations, of its criticism, of its reproach, of its allegation before filing an application. And it was this condition that led to the court to specify in the Marshall Islands case that the application must demonstrate that the respondent was aware or could not have been unaware that its views were positively opposed by the applicant. And as the late Judge Trinidad explained, and I quote, the court effectively requires an applicant state to set out its legal claim to direct it specifically to the prospective respondent state or states and to make the alleged harmful conduct clear. Ukraine has not demonstrated this or done this. As a second step, Ukraine has to demonstrate that its claim was met with Russia's manifest opposition, and it has been unable to do so either because it was impossible to do so. There simply wasn't any claim requiring a reaction from the respondent. Ukraine was aware that it could not meet the standard of the existence of a dispute as required by the court. Therefore, it decided to reverse this standard. It strove to demonstrate that the Russian Federation had allegedly held Ukraine responsible for the violation of the 1948 Convention and that it expressed its positive opposition to the allegation of genocide. However, this argument simply disregards what is essential. The dispute raised by Ukraine is on Russia's responsibility under the Convention and not on Ukraine's responsibility. And despite the fact that the rules of jurisprudence with regard to the existence of dispute do not require this explanation, I shall nonetheless demonstrate that Ukraine's arguments are baseless, and I will address the issues in 2 points briefly. First of all, Ukraine makes a reference to the use of the term genocide in the declaration of Russian agents and authorities, and yet Ukraine has not proved that in these declarations the term was indeed used within the meaning of the 1948 Convention. As to a similar declaration in another context, the court declared, and I quote, "A statement can give rise to a dispute only if it refers to the subject matter of a claim with sufficient clarity to enable the state against which that claim is made to identify that there is or may be a dispute with regard to the subject matter." End of quote. It is perhaps noteworthy to recall that when these proceedings were brought to this court, William Shabazz published a very interesting study in which he explained the distinction that needs to be made between the use of the term genocide for rhetorical purposes or when it is used to invoke the convention. He begins his analysis by quoting the declaration of President Biden, who accused Russia of committing genocide by attacking Ukraine. Many other such declarations made in other contexts may be recalled. The ILC emphasizes that a state does not invoke the responsibility of another state merely because it criticizes that state for a breach and calls for observance of the obligation or even reserves its rights or protests. For the purpose of these articles, protest as such is not an invocation of responsibility. It has a variety of forms and purposes and is not limited to involving state responsibility. Ukraine contends that Russia has nonetheless invoked Ukraine's responsibility because, according to the ILC, as it says, the invocation of responsibility can be made by taking measures. And it says, and I quote, "In this case, Russia has not merely advanced allegations that Ukraine violated the Genocide Convention, but has taken measures against Ukraine on the basis of that allegation, that is to say, recognizing the DPR and LPR and using force in and against Ukraine." End of quote. To disprove Ukraine's argument, one only has to quote relevant sentences of the commentary of the ILC in which the words conveniently selected by Ukraine are used. And the ILC underlines, and I quote, "Invocation should be understood as taking measures of a relatively formal character, for example, the raising or presentation of a claim against another state or the commencement of proceedings before an international court or tribunal." We cannot reasonably claim that the use of force or the recognition of a state can be considered as measures of a relatively formal character as the invocation of responsibility of a state under international law. The investigative committee on which Ukraine relies to make its first claim doesn't really target Ukraine itself. The committee, as its name implies, conducts investigations on crimes and atrocities committed by individuals. This committee does not belong to the executive branch of the government. It does not represent the vision of Russia on the international level. More importantly, the committee has never conducted investigation on Ukraine's responsibility. This does not fall within its remit. If it did indeed target, even if it did indeed target Ukrainian officials, it wouldn't change anything because for a dispute to occur, the court considers declarations and diplomatic exchanges between parties and the grounds presented by the authors of declarations and documents and the persons for which they are intended. In our case, the author of declarations is an organ that has the power to conduct investigations on international crimes committed by individuals without any judgment. However, Ukraine's argument is still against the practice of states with respect to prosecution of international crimes. Indeed, saying that the investigations conducted has created a dispute between Ukraine and the Russian Federation would be tantamount to recognizing, for example, that by exercising their universal jurisdiction, that the state tribunals have created, indeed, a dispute between the state of the tribunal and the individuals of that state presented for the said crimes. And such an assertion is, of course, baseless. Furthermore, supporting Ukraine would mean that one doesn't know the distinction between the international responsibility of a state and criminal responsibility.
Regarding the second point, Ukraine's reaction to the genocide declaration, it is obvious that in its written pleadings, Ukraine was unable to prove that it seriously opposed Russia's purported genocide accusation. Ukraine was aware that its position was weak, and so in its written observation tried to convince you that its silence meant it had rejected Russia's allegations. It argued that, given the seriousness of an allegation of genocide, the failure of a state to respond to such an allegation would constitute evidence that the allegation is rejected and dispute exists between the parties. Ukraine is wrong. It is not the magnitude of the accusation or its seriousness, but the existence of particular circumstances which require a reaction to determine whether silence equals a reaction or not. There is nothing to prove that we are in such a situation. Anyway, Ukraine was not able to prove this. Besides, were one to believe Ukraine, no state would ever need to prove that its opponent had challenged its claim, and consequently, the very prerequisite of the existence of a dispute would be meaningless and would lose its raison d'être. At the opposite end of the argument I've just described, Ukraine claims that it did react nevertheless. In its written observations, it's recalled first Ukrainian authorities, to which it had already referred in its memorial, and added a few additional examples. For example, but all the authorities had been looked into by the investigative committee, and the said authorities, addressed the committee in their comments. So they did not respond to a state allegation, and their attitude cannot therefore be conducive to the arising of a legal dispute. The speech made by Mr. Kuleba, the Foreign Affairs Minister of Ukraine, on the 23rd of 2022, which Ukraine relies on with some insistence, is of no help to it. Nowhere in this speech is there a reference to the 1948 Convention and its subject matter. Mr. Kuleba simply denied the allegations according to which Ukraine was preparing an attack in Donbass, and this was against the background background of the United Nations Charter. The last argument is that its National Defense Act against the military operation of Russia constituted a rejection of its allegations of genocide. There again, Ukraine is wrong. It is not a defense against the special military operation which is in play here, but its manifest and clear rejection to the allegation of genocide. In a word, Ukraine has not demonstrated that it claimed a breach of the 1948 Convention, and that his claim was opposed by Russia's reaction. It was not able to demonstrate either that Russia knew or could not ignore that Ukraine believed its genocide allegation as a breach of the Convention. Consequently, Ukraine did not prove the existence of a dispute with Russia regarding the first claim it submitted to the court. Madam President, distinguished members of the Court, this brings me to the second dispute invoked by Ukraine regarding the recognition of, by the Russian Federation of the DPR and the LPR and its use of force, which, according to Ukraine, constitute a breach of Articles 1 and 4 of the Convention. The Russian Federation has never claimed that the Convention, the Genocide Convention, authorized it to use force against Ukraine to comply with its Article 1 obligations, which is to prevent and punish genocide. According to the documents it sent to the court and to the UNSC, the Russian Federation invoked Article 51 of the United Nations Charter on self-defense and customary international law to legally underpin its conduct. Ukraine has used the pretext of the Commission of Genocide to ensure that conduct prohibited by international law, such as the use of force and recognition of states, fell within the scope of the Convention. As Judge Shui pointed out correctly, and I quote, Ukraine's contention that the Russian Federation's allegation of genocide against Ukraine is just an excuse for Russia's unlawful aggression raises doubt that this is a genuine case about genocide, an excuse for unlawful aggression between inverted commas. Needless to say, the court is not bound by the description of the subject matter of the dispute made by the applicant in its application. I quote, it is for the court itself to determine on an objective basis the subject matter of the dispute between the parties, that is, to isolate the real issue in the case and to identify the object of the claim, end of quote. The real real problem at issue in this case is not genocide, it's the use of force and the recognition of states under international law. It is with regard to these two purported disputes that the prerequisite of the existence of the dispute should be met before Ukraine introduced these proceedings. In its memorial and in its written observations, Ukraine devoted long passages to explaining that the Russian Federation had accused it of committing genocide and that it had rejected that accusation. Consequently, there is a dispute between the parties. Now, Ukraine is utterly mistaken. As I explained a while ago, to establish the existence of a dispute between the parties regarding the use of force and the recognition of states, Ukraine must first of all declared Russia's conduct to be in breach of its obligations under the Convention. Then it should demonstrate that this allegation was indeed opposed by Russia. It was unable to do so. Ukraine has made no claim regarding the use of force and the recognition of states, such that Russia would understand that there was a dispute, or there might exist a dispute, between the two parties before the filing of the application. No evidence has been adduced by Ukraine proving that it had reproached the Russian Federation for the breach by its actions of its legal obligations under the 1948 Convention. The invocation by Ukraine of the declaration made by the Foreign Affairs Minister of Ukraine on the 26th of February 2022 is of no help whatever. That declaration was posted on the ministry's site at 39 minutes past 6 p.m. on the day on which the case was brought. In fact, only 4 hours before the filing of the application. Clearly, this was not a good faith attempt by the applicant to warn its opponent of the existence of a dispute between the parties before bringing the case before the ICJ. Russia could not be expected to be aware of this declaration in order to potentially express its opposition to its content. Let us recall that the court has taken account of the passing of a reasonable amount of time between the recognition of the existence of a dispute and the filing of the application. The rule according to which, and I quote, the dispute must in principle exist prior to the filing of the application, end quote, implies that the dispute has been crystallized, quote, prior to the date of the application, end quote, so that the defendant may be in a position to react to the applicant's claim. In the instant case, the Russian Federation was in no position to know that for its opponent, the actions at issue were in breach of its obligations under the Convention. For the same reason, it was not given enough time to react to its opponent's claims. It should be recalled that in the case matters regarding the obligation to prosecute and extradite, the court did not consider Belgium's note verbal to Senegal sent 2 months prior to the application, did not consider then that this was sufficient to warn the defendant as to the existence of the claim. Ukraine also argues that its minister's declaration is far more precise in its reference to the Genocide Convention, that, for example, the declarations made by Georgia before the filing of its application in the Georgia versus Russian Federation case. This argument does not stand up to scrutiny. This is the conclusion of the court invoked by Ukraine, and I will only read out the relevant sentences which are indeed underlined. The court observes that this decree does not allege that the Russian Federation was in breach of its obligations relating to the elimination of racial discrimination. Its concerns is with the allegedly unlawful use of armed force, end of quote. Why should things be different here regarding a declaration made by the Ukrainian Foreign Affairs Ministry in the present case? This declaration dealt with the purported illegal use of force by the Russian Federation and not some hypothetical breach of the Genocide Convention. The convention only entered into play because Ukraine considered it was a pretext used by Russia to intervene. Yet, at no point did the Ukrainian ministry declare that the so-called genocide allegations, or the fact that Russia had relied on the Genocide Convention to undertake the special military operation, constitute in and of themselves a breach of the Convention. Distinguished members of the Court, Ukraine should have demonstrated that its claim, according to which the use of force and the recognition of the DPR and LPR in breach of the Convention, had met with the positive reaction of Russia before the filing of the application. But it did not do so. It could not have done so, since the military operation began at the same time as the filing of the proceedings, or the introduction of the proceedings. Therefore, since, in principle, the date for determining the existence of a dispute is the date on which the application is submitted to the court, the fact that the case was brought at the same time as the alleged breach of the Convention means the prerequisites for the existence of a dispute could not be met. Both the applicant's claim of a breach of the Convention and the defendant's reaction to the claim were made difficult by this, in fact, impossible. For there to be a dispute, it must be shown that the claim of one party is positively opposed by the other, quote-unquote. Yet, in the instant case, there was neither claim nor positive objection. Ukraine was not able to demonstrate that it had accused Russia by its military operation and occasional regions of breaching any of its treaty obligations. It did not demonstrate either that Russia had opposed the views of the applicant. Consequently, Ukraine has not demonstrated there was a dispute with Russia regarding the second of its claims amongst those it submitted to the court. Distinguished members of the court, this brings me to the third part of my presentation on the purported dispute regarding the abusive use of the Convention brought by Ukraine in its memorial. To justify this claim, Ukraine suggests three implicit obligations which, according to which, arise from the Convention. You can find them on the screen, and I shall not read them out. I would simply point out that none of these conditions for the existence of a dispute are met in this claim. It should first be said that all these affirmations rely on false premises, according to which the Russian Federation had invoked Ukraine's responsibility for the Donbas genocide, and it then reacted unilaterally to put an end to it. The fact is that the Russian Federation did not invoke Ukraine's responsibility under the Genocide Convention, and did not react to put an end to it. Allow me, Madam President, to emphasize once again. To allege that a crime has been committed on a given territory is one thing. To invoke the responsibility of the state for that same crime, according to the rules of international law, is something quite different. Ukraine clearly indicated in its application that it did not consider that the state may use force or recognize states simply by relying on the Convention. As I pointed out a moment ago, the Russian Federation did not allege either that such a right existed under the Convention, either because use of force or the recognition of states rely on other sources of international law upon which Russia explicitly based its actions. On its part, the court said clearly that, and I quote, "Moreover, it is doubtful that the Convention, in light of its object and purpose, authorizes a contracting party's unilateral use of force in the territory of another state for the purpose of preventing or punishing an alleged genocide." End of quotation. When the parties on one hand, the court on the other hand, all consider that there is no right under the Convention, can one seriously say that there is a dispute regarding this right? Surely the answer has to be no. It remains for me to point out that the Russian Federation was made cognizant of this claim by Ukraine when the memorial was filed. Yet, at the critical date of the filing of the application, this claim did not exist. There was no trace of the clearly opposed views of the parties at the time when the case was filed. Under those circumstances, one cannot conclude that there existed a dispute opposing the parties. in this respect. For all these reasons, distinguished members of the Court, the Russian Federation requests that the Court find that it does not have jurisdiction to entertain Ukraine's application. Distinguished members of the Court, this brings me to the end of my comments. I would like to thank you very warmly for your attention. I would ask you, Madam President, to give the floor to Mr. Alfredo Crozzato.
I thank Professor Azari, and I now invite Mr. Alfredo Crozzato to take the floor. You have the floor, sir.
Madam President, distinguished members of the Court, it is an honor to appear before you on behalf of the Russian Federation. My task today is to present Russia's second preliminary objection, that the Court lacks jurisdiction ratione materiae to entertain Ukraine's claims. Ukraine has come to this Court with only one potential basis of jurisdiction, Article 9 of the Genocide Convention. It provides that disputes relating to the interpretation, application, or fulfillment of the Convention, including those relating to the responsibility of a state for genocide, or for any of the other acts enumerated in Article 3, may be submitted to the Court. Ukraine submits that Russia has violated Articles 1 and 4 of the Genocide Convention. But it is evident to all, and simply undeniable, that this case is not about whether Russia has failed to prevent or punish genocide, contrary to its obligations under the Convention. What this case is really about is the legality of the special military operation and the recognition of the DPR and LPR as states. The legality of these actions not under the Genocide Convention, but under the UN Charter and customary international law. The entire case before you hinges upon this. This, Madam President, members of the Court, calls for caution. Accepting Ukraine's position would be tantamount to rewriting the Convention and transforming its subject matter. It would completely overturn your well-established jurisprudence on the limits of compromissory clauses. It would be a clear circumvention of the fundamental principle of state consent to the jurisdiction of the Court. My presentation will be as follows. I shall first make some general remarks about Ukraine's case. I will show that the claims of Ukraine do not concern the Genocide Convention, but other rules of international law. Ukraine's attempt to shoehorn those claims into the Convention leads to several contradictory assertions and propositions that do not have any basis in the Convention. I shall then set out the test for establishing the Court's jurisdiction ratione materiae under a compromissory clause, and recall what the Court has said about the scope of Article 9 in previous cases. The Court has already carefully delineated its jurisdiction under this provision. It does not confer upon the Court the powers that Ukraine seeks to rely on. I will then show that Ukraine's key contentions in this case are fundamentally wrong as a matter of international law. First, there is no obligation under the Convention to act within the limits of international law so as to incorporate an indefinite number of obligations unrelated to the Convention. Second, and to conclude, I will show that there is no right under the Convention that could have been abused by Russia. Madam President, let me start with some general remarks on Ukraine's claims. Russia's second preliminary objection concerns conclusions C and D of Ukraine's memorial. Ukraine asks the Court to adjudge and declare that by using force and recognizing the DPR and LPR, Russia violates Articles 1 and 4 of the Genocide Convention. Articles 1 and 4 are well known, but it is important to recall what they say. Article 1 reads the contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law, which they undertake to prevent and punish. Article 4 provides that persons committing genocide or any of the other acts enumerated in Article 3 shall be punished, whether they are constitutionally responsible rulers, public officials, or private individuals. One would expect an applicant under the Genocide Convention to claim that the contracting party had failed to prevent genocide or to punish its perpetrators. The applicant may request that those obligations be complied with by, for example, adopting measures to prevent further acts of genocide, prosecuting offenders, and making reparation to victims. These are, after all, the obligations laid down in Articles 1 and 4 of the Convention. Ukraine claims something quite different. It argues that these provisions have been breached through acts that have no apparent connection with the required conduct, the use of force, and the recognition of certain entities as states. Articles 1 and 4 do not refer to the use of force or to the recognition of states. The same is true for the preamble and other articles of the Convention, and for the drafting history. Ukraine's conclusions C and D are therefore, on any reading, foreign to the Convention, outside the scope of the Convention. The subject matter of the treaty simply does not deal with the use of force or the recognition of states. Ukraine cannot avoid accepting this simple truth, and this should be the end of the story. Yet Ukraine insists on transforming the scope of the Convention, advancing 3 propositions, all of which are seriously flawed. First, Articles 1 and 4 contain, in Ukraine's view, an all-embracing obligation to act within the limits of international law when preventing or punishing genocide. The effect of this alleged obligation will be to incorporate into the Convention all obligations of states from other sources of international law, and to expand beyond measure the Court's jurisdiction under Article 9. Second, Ukraine argues that a state may not abuse Articles 1 and 4 by using force against another state or by recognizing states within the territory of another state, without sufficient evidence of genocide or a risk of genocide. This claim, based on an abuse of right, presupposes that the Genocide Convention confers a right on states to unilaterally use force, a right of humanitarian intervention, as well as a right to recognize states. Third, ignoring the Court's jurisprudence, Ukraine suggests that Article 9 is a unique, broad, or wide compromissory clause. Since Ukraine's obvious goal is to have the Court pass judgment on matters that do not fall within the subject matter of the Convention, its case is inevitably riddled with inconsistencies and surprising propositions. I will mention just a few. First, there is no doubt that an actual breach of the obligation to prevent or punish genocide is not claimed by Ukraine. In the Bosnian genocide case, the Court clarified that the obligations to prevent and punish arise if genocide has been committed, or if there is a serious risk that genocide may be committed. The Court also found that the state can be held responsible for breaching the obligation to prevent genocide only if genocide was actually committed. Ukraine's case is based on 2 contradictory premises. On the one hand, it states that no genocide has been committed in Donbass, and that there is no risk of genocide. So for Ukraine, the application of Articles 1 and 4 of the Convention have not been triggered. There being no genocide, Russia clearly cannot be held responsible for failing to prevent or to punish it. On the other hand, as I mentioned, Ukraine asserts that the Convention contains an obligation to act within the limits of international law when preventing or punishing genocide, and that Russia has violated this alleged obligation by breaching the UN Charter and customary international law. This logic is clearly not consistent with your case law. It makes no sense to say that Russia has violated an obligation to act within the limits of international law when preventing or punishing genocide, and at the same time, that in this circumstance, Russia had no obligation to prevent or punish. This convoluted reasoning confirms that the Convention is being instrumentalized to address a much broader and quite different dispute between the parties. Madam President, another flaw in Ukraine's case is the lack of a legal basis for the alleged right not to be subject to allegations of genocide, false or otherwise. This is related to Ukraine's most remarkable suggestion that the Convention may confer a right to use force against a state or to recognize states within the territory of another state for the purpose of preventing or punishing genocide. That is not only very controversial under customary international law, it has no basis whatsoever in the Convention. In its memorial, Ukraine suggests that states have an obligation to produce evidence of genocide before taking measures to prevent or punish, or before making an allegation of genocide. It argues that not doing so would contravene the limits of Articles 1 and 4, and that it has a right not to be subject to a false claim of genocide. At the same time, Ukraine appears to be of the view that when a state does have evidence of genocide, that state may act to the detriment of another state or may harm that other state. Ukraine does not define what detriment or harm means exactly, but it seems to refer, for the purpose of this case, to the use of force and the recognition of states. You may now see two excerpts on your screens. In the memorial, Ukraine states that Articles 1 and 4, at a minimum, require a state to conduct proper diligence before a state takes action to the detriment of another state for the purpose of preventing or punishing genocide. The implication here appears to be that if a state does conduct proper diligence, the Convention empowers it to take action to the detriment of another state, for example, by unilaterally using force. Ukraine also states that Articles 1 and 4 do not authorize, but rather prohibit, one contracting party harming another contracting party under the guise of preventing and punishing a genocide that has been alleged without basis or due diligence. Here, Ukraine leaves a key question open: whether the Convention prohibits harming another state when the allegation of genocide is correct, or at least based on due diligence. Madam President, the Court no doubt applies the notion of due diligence, not as Ukraine suggests, to back up statements regarding genocide, but to establish whether a state has discharged its obligation to prevent genocide, where this obligation has been triggered. Mere allegations of genocide or of a risk of genocide do not constitute a breach of Articles 1 and 4. The Convention and its drafting history say nothing about the right not to be subject to an allegation of genocide. As noted by Judge Benuna at the provisional measure stage, the Convention does not cover, in any of its provisions, allegations of genocide. Ukraine seems to finally accept this in its written statement. But Ukraine's most remarkable suggestion, as I just showed, is that if a state has produced evidence of genocide, it may, under the Convention, take action to the detriment of another state or harm another state. This is a crucial aspect of the case before you. It lies at the heart of Ukraine's claims, and in particular, its reliance on an abuse of rights doctrine. Let us be clear. Accepting this proposition would be to say that the right of humanitarian intervention exists under the Convention. The Court is well aware that this notion has already been rejected by most members of the international community. For avoidance of doubt, I must recall that Russia's position on this matter, the use of force, is regulated by the UN Charter and customary international law, not by the Convention. The Genocide Convention does not authorize, confer a right, or impose an obligation to use force to prevent or punish genocide. Madam President, members of the Court, after these general remarks, I now turn to the test to be applied to establish the Court's jurisdiction ratione materia in this case. That test, in a nutshell, is whether a claim is capable of falling within the provisions of the treaty invoked by the applicant. To answer this question, the Convention must be interpreted to determine its scope and whether it may be breached in the manner alleged by the applicant. This is not a question of mere plausibility, a standard applicable at the provisional measures stage. The Court has a duty to ascertain that its jurisdiction is properly established before proceeding to the merits. This is well established in your jurisprudence. In the oil platforms case, the Court stated that the Court cannot limit itself to noting that one of the parties maintains that such a dispute exists and the other denies it. It must ascertain whether the violations of the Treaty of 1955 pleaded by Iran do or do not fall within the provisions of the treaty. The same test was applied recently in certain Iranian assets and in immunities and criminal proceedings. In applying this test, the court is entitled to interpret the submissions of the applicant and to identify the object of the claim. In its written statement, Ukraine urges the court to deal with the second preliminary objection at the merit stage. They suggest that the court should accept Ukraine's factual claims as true. But this is beside the point. At this stage, the court is called upon to interpret the Convention in the light of Ukraine's claims to ascertain its jurisdiction. A preliminary objection may be deferred to the merits if it raises complex questions of fact. Russia's second objection does not raise such questions. All the court has to do is interpret Articles 1 and 4 and determine whether they contain an indefinite number of obligations through an alleged obligation to act within the limits of international law, or a right to use force and recognize states, considering that in the absence of such rights, there can be no abuse. I would also note, Madam President, an issue that Ukraine wrongly presents as factual. It asks the court to accept pro term its own interpretation of Russia's legal justification for the special military operation and the recognition of the DPR and LPR. This is not a question of fact, but one of law. Russia is here today precisely to explain what its legal position is, as it is, of course, entitled to do. Madam President, I pause here if you think it appropriate to have the coffee break now, or I can continue for another 5 minutes.
Further, Mr. Casado. Thank you.
Thank you. I now turn to your previous decisions concerning the scope of Article 9 of the Convention. These decisions leave no place for doubt. The court's jurisdiction under Article 9 is limited to violations of the Convention itself. Your 2007 judgment in Bosnia genocide is particularly relevant. The court said it has no power to rule on alleged breaches of other obligations under international law not amounting to genocide. That is so even if the alleged breaches are of obligations under peremptory norms, or of obligations which protect essential humanitarian values, and which may be owed erga omnes. This finding was unanimous. Sir Christopher Greenwood, writing as a commentator, explained that the court was able to rule only on the issues relating to the Genocide Convention, and could not consider other aspects of the broader dispute between the two countries, such as the application of the international law on the use of force. The court reaffirmed this understanding in the Croatia genocide case. It was determined that Article 9 confines the court to disputes regarding genocide. The jurisdiction under Article 9 is confined to obligations arising under the Convention itself, and that the court can only rule within the limits imposed by the Convention. We note, Madam President, that Ukraine proposes a novel interpretation of Article 9 in its written statement. It suggests that Article 9 would give the court a broad, wide, or comprehensive jurisdiction. Ukraine puts emphasis, for example, on the word fulfillment, using a dozen dictionary definitions. They also provide an incomplete account of the drafting history of Article 9, focusing on a single statement at the Sixth Committee. And Ukraine quotes selectively the views of one. These arguments are wrong on several grounds, which we shall address in more detail next week. Today I will stress only one. Ukraine completely ignores the interpretation of Article 9 that the court has already adopted. Indeed, your jurisprudence is clear. There is no reason to depart from it or to sweep it under the carpet. Ukraine is asking you to do exactly what you said you cannot do under Article 9, to pass judgment on and even order reparation for alleged violations of rules of international law that cannot arise under the Genocide Convention, but under the UN Charter and customary international law. This could not be regarded as a case relating to the interpretation, application, or fulfillment of the Genocide Convention. So put simply, the violations of Articles 1 and 4 that Ukraine alleges are grounded or predicated on a violation not of the Convention, but of other rules of international law. Determining that Russia has violated those other rules, which Ukraine admits originate outside the Convention, is a sine qua non for its claim to succeed. Of course.
Minutes. The sitting is adjourned. Please be seated. The sitting is resumed, and I now invite Mr. Crossato to complete his presentation. You have the floor, sir.
Thank you, Madam President. Now, let me address Ukraine's specific arguments in support of what I was saying just before the break. Ukraine relies primarily on the Bosnia genocide case, where the court clarified the nature of the obligation to prevent genocide. In that case, the court noted that the obligation to prevent is one of conduct and not of result, and that a state does not incur responsibility simply because the desired result is not achieved. The court then indicated that various parameters operate when assessing whether a state has duly discharged the obligation concerned, one of which is the capacity to influence effectively the action of persons likely to commit or already committing genocide. The court added that this capacity must be assessed by legal criteria, since it is clear that every state may only act within the limits permitted by international law. The meaning of this last statement, when read in context, is straightforward. A state cannot be found responsible for failing to prevent genocide if international law imposes on it obligations that may limit its capacity to do so. This is very different from what Ukraine argues in this case. The court avoided an interpretation of the Convention that would require states, when preventing genocide, to do something that is prohibited by other rules of international law. Ukraine's position is that doing something that is prohibited by other rules of international law could trigger responsibility under the Convention itself. This logic is far removed from the court's finding in 2007. In the Bosnia genocide, the court surely did not intend to conflate obligations arising under the Convention and obligations arising under other rules of international law, nor to expand its jurisdiction beyond that conferred by Article 9. Again, as the court has made clear, it has no power to rule on alleged breaches of other obligations under international law. Ukraine also relies on the court order on provisional measures. The order stated that acts undertaken to prevent and punish genocide must be in conformity with the spirits and aims of the United Nations. And that I quote, "It is doubtful that the Convention, in light of its object and purpose, authorizes a contracting party's unilateral use of force." Madam President, states must, of course, respect their obligations under international law, including under the UN Charter, also when executing or giving effect to a treaty. This goes without saying. And it is true not only for the Genocide Convention, but for all treaties. Ukraine says in its written statement that a state may not claim to enforce international law by violating international law. But there is nothing new here. The key point is that its obligations arise each from its own distinct source. If a state executes a treaty, and in doing so violates obligations arising under other rules of international law, the responsibility of that state will be triggered with respect of those other rules alone, but not under the treaty in question. Ukraine seeks to get around this by saying that the Convention includes an obligation to act within the limits of international law. But this is not the case unless that can be established as a matter of treaty interpretation. Otherwise, such an obligation could be read into any treaty. This would have a profound impact on the extent of jurisdiction under compromissory clauses. It would open the door for states to come to the court or other tribunals, invoking a particular treaty with the objective of solving a broader or entirely different dispute. I should stress again that Russia does not find it doubtful whether the Convention authorizes the use of force for the purpose of preventing or punishing genocide. Russia's position, as I recalled, is that the Convention does not confer a right of humanitarian intervention. The fact that a treaty does not authorize a certain conduct does not mean that the treaty prohibits that conduct. Treaties have a limited subject matter. They do not regulate states' relations generally. Treaties are silent on several issues that may be governed by other rules of customary or conventional law or general principles of law. It would be wrong to suggest that conduct not authorized by a treaty, simply because it is beyond its scope of application, may constitute a breach of the treaty. So whether the Genocide Convention authorizes the use of force is not the relevant question. What the court must determine is whether the Convention governs the use of force at all, whether it prohibits it, or whether it confers a right to use force, and if so, subject to which conditions. Russia's position, and it appears that Ukraine to some extent agrees, is that the Convention does not do any of these things. In the present context, the use of force is regulated by the UN Charter and customary international law exclusively. Ukraine also tries to justify its interpretation of the Convention, relying on its preamble, Articles 8 and 9, and the UN Charter. The preamble of the Convention makes clear that its object and purpose is to criminalize genocide under international law and to liberate mankind from this scourge. Genocide is contrary to the spirit and aims of the Charter. And of course, international cooperation may be required to achieve the goals of the Convention, something that could be said for all multilateral treaties. They all require cooperation among states. Russia stands by this object and purpose, but not a single word in the preamble is evidence of states' discernible intention to incorporate all the rules of international law. Article 8 does not impose specific obligations on the contracting parties, as it is clear from the words may and as they consider appropriate. It simply points out some of the ways in which states and competent UN organs may or may not seek to prevent and suppress genocide. In Bosnia genocide, the court noted that Article 8 may be seen as completing the system by supporting both prevention and suppression at the political level, and that Article 8 does not confer on the court any functions or competence additional to those provided for in its statute. This was reaffirmed in the Gambia versus Myanmar case, where the court added that Article 8 does not govern the seizing of the court. As for Article 9, it is well established that compromissory clauses are adjectival, not substantive, in their nature and effect, and do not determine whether the parties have substantive rights. It follows that Ukraine's reliance on Articles 8 and 9 is clearly misplaced. There is nothing in these provisions showing, even remotely, that Articles 1 and 4 incorporate an indefinite number of obligations arising from international law. Madam President, the Court has already dealt with attempts to expand the material scope of treaties through incorporation. The Court addresses this with caution, requiring clear, unequivocal evidence of states' intention to that effect. It is indeed important to proceed like this. If not, compromissory clauses could be misused to bring claims unrelated to the treaties in question and to circumvent the principle of state consent to the Court's jurisdiction. A few examples illustrate the Court's approach. In its platforms, for example, Iran argued that Article 1 of the 1955 Treaty of Amity incorporated rules of international law concerning the use of force. The Court rejected this argument, noting that the object and purpose of the Treaty of 1955 was not to regulate peaceful and friendly relations between the two states in a general sense. Article 1 cannot be interpreted as incorporating into the treaty all of the provisions of international law concerning such relations. The Genocide Convention, likewise, does not regulate relations between states in a general sense. It is aimed at liberating mankind from genocide and ensuring that this crime is prevented and punished. This is no doubt a very important purpose, but it is also specific in scope. In immunities and criminal proceedings, Equatorial Guinea claimed a violation of sovereign immunities by France, relying on Article 4, Paragraph 1 of the Palermo Convention, which provides that states shall carry out their obligations in a manner consistent with the principles of sovereign equality and non-intervention. In the applicant's view, this provision incorporated rules on immunity, which states had to respect when fulfilling or executing their obligations under that convention. Even in the face of this express language, the Court did not agree with Equatorial Guinea's argument. It said that Article 4.1 does not impose through its reference to sovereign equality, an obligation on state parties to act in a manner consistent with the many rules of international law which protect sovereignty in general, as well as all the qualifications to those rules. Article 4 does not incorporate the customary international rules relating to immunities of states and state officials. The similarities between the claims by Equatorial Guinea and Ukraine are obvious. In the present case, Ukraine argues that the Genocide Convention obliges states to act in a manner consistent with international law when executing their obligations. Equatorial Guinea also argued that states had to carry out their obligations under the Palermo Convention in a manner consistent with the principles of sovereign equality and non-intervention. In both cases, the goal was the same: incorporating rules into a treaty and expanding the court's jurisdiction ratione materiae. Equatorial Guinea sought to incorporate into the Palermo Convention rules relating to immunities. Ukraine, somewhat more ambitiously, seeks to incorporate all of international law into the Genocide Convention. But there is a crucial difference. In immunities and criminal proceedings, there was a textual basis in the Palermo Convention supporting an incorporation of the kind Ukraine seeks in this case, Article 4.1. But despite the express language and the close connection between sovereign equality and the rules on immunity, the court did not consider that those rules were incorporated. There was no clear reference to them in the Convention or the Travaux. The court rather agreed with France that the Convention was not intended to organize in a general way the legal relations between states in light of the principle of sovereign equality, nor to create a system of immunities. There is no provision like Article 4.1, Genocide Convention. There is also no indication in the text or the Travaux that the Convention itself contains an obligation to act within the limits of international law when executing the Convention. This alleged obligation, therefore, has to be conjured up from thin air. This being so, Ukraine's position cannot succeed any more than Equatorial Guinea's position did. The court dealt with a similar issue in certain Iranian assets, where Iran argued that the 1955 Treaty of Amity incorporated customary rules on state immunity. The court interpreted in detail the articles invoked by Iran and concluded that none of them were capable of bringing within the jurisdiction of the court questions of immunity. Iran's position was based on a reading of the Treaty of Amity that was at least plausible, taking into account several textual elements that to some extent supported a potential incorporation. Yet the court dismissed it. In the present case, Ukraine's position finds no support, none, in the text of the Convention, nor in its object and purpose, nor in its drafting history. There is no link between the Convention and other rules of international law, no renvoi that could lead to an incorporation. Madam President, members of the Court, the legality of the use of force cases are also relevant in this context. At the outset, I should recall that the bombing of Yugoslavia by NATO member states was carried out as an intervention alleging human rights violations and genocide. Unlike Russia, those states did not justify their use of force by reference to the UN Charter. The court ultimately concluded that it did not have jurisdiction to hear the applicant's claims. In its order on provisional measures, the court decided that the use of force did not necessarily amount to genocide, at least absent the required special intent. The court did not see the allegations of genocide as creating a jurisdictional link between the Convention and the rules on the use of force. The respondent states indeed made it clear that the issues relating to the use of force and the Convention are distinct and should not be confused. Canada, for instance, stated that the dispute between Canada and the applicant has nothing to do with breaches of the Genocide Convention. The Convention has been invoked as an artificial basis for bringing proceedings to which the compulsory jurisdiction of the court does not extend. For France, the court is without jurisdiction to rule on the issues concerning alleged violations of the UN Charter. Those issues do not fall within the provisions of Article 9 of the Convention. Germany, considered that by presenting a long list of breaches of rules of international law, Yugoslavia openly admits that the bulk of the dispute lies outside the confines of the Convention. The United Kingdom was also clear. Jurisdiction under Article 9 would not extend to disputes regarding alleged violations of the rules of international law, such as the provisions of the UN Charter relating to the use of force. Madam President, members of the Court, we could go on citing similar statements, but I think the point is clear. For the respondents in the legality of the use of force cases, the Convention did not regulate matters relating to the use of force. It does not cover claims on alleged violations of the UN Charter. The Court did not disagree, and it did maintain the position, as we have shown, that its jurisdiction under Article 9 is limited to violations of the Convention itself. Everything we have explained so far can lead to only one conclusion. The Convention, and in particular Articles 1 and 4, do not incorporate other rules of international law through an obligation to act within the limits of international law. All claims by Ukraine, based on this incorrect premise, must be rejected for lack of jurisdiction ratione materiae. Madam President, I now move to the last part of my presentation, of rights. As I mentioned, Ukraine argues that Articles 1 and 4 of the Convention oblige states not to misapply, misuse, or abuse the Convention. This claim must also be dismissed to the extent that it requires the Court to exercise jurisdiction over alleged violations of the UN Charter or customary international law. The Court's jurisdiction under Article 9 is, again, limited to breaches of the Convention itself. But Ukraine's claim on abuse of rights raises an additional issue concerning the Court's jurisdiction ratione materiae that I will address separately. For a claim of abuse of rights to be plausible, one must establish, at a minimum, the existence of the right that was allegedly abused. The fundamental flaw in Ukraine's position is that it cannot identify any right under the Convention that could have been abused by Russia. Ukraine's arguments in this regard are notable for their lack of clarity. At times, it states that Russia has abused Articles 1 and 4 of the Convention. It also claims that Russia has somehow abused the Convention as a whole. And Ukraine often suggests that Russia has abused either rights or obligations, as if these concepts were indistinguishable for purposes of applying an abuse of rights doctrine. In its written statement, Ukraine tries to clarify this by saying that the obligations under Articles 1 and 4 of the Convention are also rights. In other words, states not only have an obligation to prevent and punish genocide, they have a right to do so. This proposition is extremely doubtful. It is well known that when a treaty imposes an obligation on states, the only correlative right for other states is to see that obligation fulfilled. But even if Ukraine were correct, quote none, this would not solve the core of the problem. What right or obligation under the Convention is at stake in this case? Ukraine refers to the right to invoke the responsibility of another state. But if that right is contained in the Convention itself, it can only be in Article 9, which Russia has not invoked. It is Ukraine who instituted the present proceedings, not Russia. And in any event, if a state wrongly invokes the responsibility of another state, that is just that, a mistaken invocation of responsibility. The claim of the invoking state may be rejected by the court, but this cannot amount to an abuse of rights, for otherwise every applicant whose claims are dismissed could be accused of abusive behavior. This leaves Ukraine only one potential right, a right under the Convention to use force against another state and to recognize states within the territory of another state to prevent or punish genocide. As I noted earlier, this is Ukraine's most extraordinary suggestion in this case, even if it avoids stating it in clear terms. And there are indeed serious contradictions in Ukraine's position. On the one hand, Ukraine's written pleadings suggest that such rights, as I just listed, may exist under the Convention. Ukraine's view appears to be that when a state has sufficient evidence of genocide, that state may harm or take action to the detriment of another state. On the other hand, Ukraine itself denies the existence of such rights, and rightly so. In its written statement, Ukraine says that it has never argued that the Convention contains a right to use force. The position now seems to be the one on your screens. By improperly using force and recognizing the DPR and LPR for the stated purpose of bringing a violation of the Genocide Convention to an end, Russia has abused its undertaking to prevent and punish genocide and its right to take lawful action to end genocide. This is not a model of clarity. Ukraine refers, for example, to improperly using force. Does improperly mean unlawfully or something else? Ukraine then speaks of abusing an undertaking and a right at the same time, confusing these concepts. And finally, Ukraine refers to a right to take lawful action to end genocide, but it never explains what that lawful action might be. Ukraine's silence is astounding, given that its claim on abuse depends precisely on whether the Convention confers a right or imposes an obligation to use force and recognize states to prevent or punish genocide. If the answer is no, as it clearly is, then there is no room for an abuse of rights argument. There will be no right to be abused. So in short, the position is as follows. Ukraine's claim of abuse of rights depends at a minimum on the existence of a right under the Convention to use force and recognize states to prevent and punish genocide. Ukraine has not established the existence of such rights. It only obscurely suggests that they may exist and ultimately ends up denying their existence. Russia also considers that such rights or obligations do not exist under the Convention. This leaves us with the following question. If the applicant, the respondent, and the court all reject the existence of a right under the Convention to use force or recognize states, what is left for Ukraine's claims? The answer is nothing. An abuse of rights cannot apply to imagined rights that one party may ascribe to the other, while in fact both parties and the court deny them. One cannot abuse something that does not exist. Ukraine's claim, therefore, is simply moot. It cannot be based on any right or obligation contained in the Convention. This should lead you to dismiss Ukraine's claim for lack of jurisdiction ratione materiae. The abuse of a right that does not exist under the Convention cannot be the subject of proceedings under the compromissory clause of the Convention. There is no need to defer this matter to the merits because there is no real disagreement between the parties. And the court should avoid sending a message that the Convention may contain a right to unilaterally use force or to recognize states within the territory of another state. The Convention does not contain such rights. Madam President, members of the court, this concludes my presentation. I thank you for your kind attention and kindly request you, Madam President, to invite Professor Xianhoi to the podium to present Russia's third and fourth preliminary objections.
I thank Mr. Crissato, and I now invite Professor Xianhoi to address the court. You have the floor, Professor.
Madam President, distinguished judges of the court, it is an honor for me to appear before you again on behalf of Russia. I will first present Russia's third preliminary objection regarding the inadmissibility of the new claims advanced in Ukraine's memorial. The statute and the rules of the court require the applicant to carefully formulate its claims before bringing a case. Article 40 of the statute provides that the subject of the dispute must be indicated in the application instituting proceedings. Article 38 of the rules further clarifies this requirement and envisages that the application shall specify, and I quote, the precise nature of the claim. The court has emphasized that these provisions are essential from the point of view of legal security and the good administration of justice. Thus, although a state's right to supplement and amend its claims, after filing the application is not precluded, there is a high threshold for the exercise of that right. Ukraine quoted from a commentator to the effect that the exposition of the subject of the dispute and the nature of the claim in the application is expected to be supplemented and elaborated in further proceedings, insinuating much more than what the commentator said. The commentator has the honor to stand before you right now, and he cannot resist reporting that Ukraine's quotation is incomplete. The commentator also suggests the court's case law on limits and restrictions. Of course, supplementation and elaboration can be done not with limitless freedom, but only with a latitude that must be restricted to some extent. That restriction is embodied in the criteria for admissibility of new claims established in our rule, subsequently followed in several cases in this court and beyond. As originally articulated and applied and recapped in subsequent cases, the ALO in particular, the criteria can be summarized as follows. First, the application is the basis on which it is to be determined whether or not a claim is new. Ukraine's attempt to put weight on the very late presentation of the case, applying the Nauru criteria as if presentation in the memorial would be permissible, is without merit. As the court emphasized in Diallo, and I quote, "In this respect, it is the application which is relevant." Second, a new claim is inadmissible. It's not inadmissible, it's a facto. The decisive consideration is the nature of the connection between the claim and the court and the one formulated in the application. Third, regarding the nature of such connection, to find a new claim has been included as a matter of substance in the original claim, it is not sufficient that there should be links between them of a general nature. Fourth, to be admissible, a new or additional claim must have been implicit in the application or must arise directly out of the question, which is the subject matter of the application. In assessing whether the Nauru criteria has been met, the court has held that a new claim is inadmissible when, in order to address it on the merits, the court has to examine a number of issues which are extraneous to the original claim, and that the claim is new and inadmissible when it is distinct from the original claim. In the present case, Ukraine has significantly altered the vast majority of its submissions and introduced new ones. Above all, this showcased that no dispute under the Genocide Convention existed between the parties at the time Ukraine filed its application. Now, let us look at Ukraine's original claims as presented in its application. Initially, Ukraine asked the court to find that it did not violate the Genocide Convention, that Russia cannot take actions in or against Ukraine to prevent or punish an alleged genocide in Donetsk and Lugansk, that Russia's recognition of the DPR and LPR, I quote, has no basis in the Genocide Convention, and that the special military operation, I quote, has no basis in the Genocide Convention. Each of these requests is conditioned by a false claim of genocide element. Now, I come to the new claims presented by Ukraine in its memorial, and I will show that each of them fits the notion of inadmissible new claims as defined by the court's rules and jurisprudence. Let us start with paragraph 178b of Ukraine's memorial. Here, Ukraine asks the court to adjudge and declare that there's no credible evidence that Ukraine is responsible for committing genocide. But initially, Ukraine asked the court to find that no act of genocide within the meaning of Article 3 of the Convention had been committed in Donetsk and Lugansk. Ukraine's current request, as stated in the memorial, is considerably different. Ukraine tellingly dropped its initial claim that there are no genocidal acts in Donetsk and Lugansk. Its submission concedes that there may have been such acts, but adds a nuance that the Ukraine, as a sovereign state, is not responsible for them. These are two very different, distinct claims. It is one thing to allege that there has been no genocide in the Donbass, and quite a different thing to disclaim attribution of such acts to Ukraine. Thus, Ukraine's new claim in the memorial requires the court to examine issues that are extraneous to Ukraine's original claim and is neither implicit in its application nor does it arise directly out of the question, which is the subject matter of that application. And I'll come to paragraph 178C and D of the memorial. Originally, Ukraine asked the court to confirm Russia's special military operation and recognition of the DPR and LPR had no basis in the Genocide Convention. In the memorial, Ukraine changed its claim and seeks to establish Russia's responsibility for allegedly violating Articles 1 and 4 of the Convention. There's a glaring difference between actions that have no basis in a treaty and actions that violate that treaty. In Equatorial Guinea versus France, the court used the phrase, find the basis in the Convention, as a synonym of exist under the Convention. If an action has a legal basis in a treaty, then this action is allowed by the treaty or at least is regulated by it. This is clearly not the case as violating the treaty. Action that is not allowed or regulated by a source of law does not necessarily violate it. To illustrate, a state's right to explore the moon has no basis in the UNCLOS, but it would be wrong to say that the UNCLOS is violated every time when a state sends something to the moon. Thus, a violation of the Convention claim cannot be said to have been implicit in a no basis in the Convention claim, or has arisen directly out of it. Ukraine's inadmissible alteration of claims is further corroborated by the changes in the relief it seeks in paragraph 179A to F of the memorial. As mentioned earlier, Ukraine's requests in the application concern only the actions that Russia could take, I quote, on the basis of its false claim of genocide. Its requests in paragraph 179 of the memorial, however, do not even contain the term genocide, but continuously feature the use of force and the recognition of the DPR and the LPR as the object of Ukraine's claim. This change of claims clearly reflects Ukraine's true intention to make the court consider a claim relating to everything but genocide. The relief sought by Ukraine, as well as its claims, therefore are completely extraneous to the Genocide Convention and are therefore neither implicit in Ukraine's application, nor could they arise directly from its subject matter. These new claims have completely transformed the case from its original one about the Convention into a new one about the use of force. Finally, Article 4 of the Convention is not mentioned at all in the application, but Ukraine sprinkles Article 4-based claims in different places in the memorial. Such claims are completely new and are inadmissible. There's no good reason for the court not to follow the ILO's decision in holding an analogous new claim inadmissible in Louisa, which decision is in fact a product of that tribunal following this court's now-ruled precedent. It is important for a court of justice to hold such new claims inadmissible, or else the court will give the unfortunate misimpression that it is just another hall of unwieldy discussion. And further, in the context of this very treaty, that as long as the word genocide is mentioned in the application, all claims tangentially about the Convention can be added later on in the proceedings, leading to great abuse of it. In any event, the now-ruled criteria cannot be met here. First of all, the contradiction between the original claim, i.e., that no act within the meaning of Article 3 were committed in relevant areas, and an Article 4-based claim, which states that persons committed genocide or any other act enumerated in Article 3 shall be punished, cannot escape our eyes. An Article 4 claim, which is based on the presence of Article 3 Act, cannot be implicit in the original claim. For a finding of absence of Article 3 Act, nor can it arise directly out of the question which is the subject matter of the application. The clear and specific terms of Article 4 are not susceptible to creative interpretation without doctoring it. Ukraine tries to cure the problem by asserting that Ukraine's Article 4 claim, however, is a related claim under Article 1 and arise from the same subject matter. This, in fact, is saying that the link is of a general nature. Such a link, even if correct, is insufficient to rescue its new claims. In the end, Ukraine resorts to a conclusive statement that the memorial's invocation of Article 4 in conjunction with Article 1 arises directly from the subject matter of the application. The nature of Article 4 and of the original claim is such that adding Article 1 or any other articles would not remove the contradiction between Article 4 claims and the original claim, nor can it establish a link between them that will meet the Nauru criteria. Furthermore, Ukraine also mentioned that in the provisional measures order, in this case, the court understood Article 4 was implicated. This is incorrect. First, the court did not state a position, but merely related what Ukraine argued. I checked the paragraphs. Furthermore, since Article 4 was not mentioned at all in the application, the court's mention has no impact, definitely none on the objecting party, as the dialogue shows. Ukraine attempts to rescue its new claims by describing them as falling within, relating to, or related to the subject matter of the dispute or its application. In the relevant section heading of the written statement, paragraph 146 and paragraph 152, respectively, this shows that Ukraine itself can only muster links of a general nature between its new claims and the original claim, which Nauru, tells us that are insufficient for such new claims to be admissible. This shows that the Nauru criteria are not met here. Ukraine also occasionally describes Russia's arguments as mere semantics without substance. I believe the arguments I have highlighted have plenty of substance in them. Ukraine further tries to portray the transformation of its claims as mere adding specificity to the submissions it made in the application. This characterization is, to say the very least, very far from reality. This cannot be mere adding specificity to the claims when your submissions change not only in form but also in substance. The submissions in the application refer only to Article 3 of the Genocide Convention without mentioning Article 1 or Article 4, and the submissions in the memorial do not mention Article 3 at all, but instead refer to two completely different articles, Articles 1 and 4. This cannot be mere adding specificity to the claim when each of the submissions in the application refer to a false claim of genocide. And in contrast, the memorial makes no mention of a false claim of genocide, and instead half of Ukraine's submissions refer to the term use of force, or issues of customary international law, having nothing to do with the convention. And this is clearly not mere adding specificity to the claim when the submissions in the memorial are at odds with what Ukraine claimed in the application about the starting point of the case theory, whether there were any genocidal acts in the DPR and LPR in the first place. Madam President, members of the court, what Ukraine presents as clarification of the initial case is in fact a completely different new claim, implying its own factual background, different subject of liability, and distinct legal basis. Ukraine's submissions presented in the memorial are neither implicit in the application nor arise directly out of the question which is the subject matter of the application. Therefore, Russia asks the court to declare inadmissible Ukraine's new claims presented in paragraph 178b to d and paragraph 179a to f of the memorial. Madam President, distinguished judges of the court, I now come to Russia's fourth preliminary objection, and I will demonstrate why a judgment of this court could render on Ukraine's claims will be devoid of any practical effect. This court has been established as a court of justice to deliver justice. To deliver justice, the court must be also the guardian of its own judicial integrity. As the court teaches in the Northern Cameroon's case, the court should only pronounce judgment that have practical effect, judgment that can affect existing rights and obligations of the parties, thus removing uncertainty from their legal relations. Or put another way, judgments that would be capable of effective application or susceptible of compliance or execution. In our case, the critical question is, can the court render a judgment under the Genocide Convention that will affect existing rights and obligations of the parties, thus removing uncertainty from their legal relations surrounding the special military operation or Russia's recognition of the DPR and LPR, or would be capable of effective application or susceptible of compliance or execution? The answer is a resounding no. First, the rights and obligations of the parties surrounding the special military operation or Russia's recognition of the DPR and LPR arise under the right of self-defense under Article 51 of the UN Charter and relevant customary international law, over which the court has no jurisdiction. Any potential judgment of the court in this case instituted under the Genocide Convention cannot possibly or properly address the right of self-defense under Article 51 of the UN Charter and relevant customary international law, and therefore cannot affect the rights and obligations or remove the uncertainty in legal relations arising under these bodies of law. Secondly, any potential judgment that the court might render under the Genocide Convention in this case would not be capable of effective application or susceptible of compliance or execution under Article 51 of the UN Charter and relevant customary international law. This is so because the Genocide Convention on the one hand and Article 51 of the UN Charter and relevant customary international law on the other are distinct bodies of law, and a decision made under one does not prejudge the lawfulness of the same act under the other. More importantly, a decision under the Convention cannot override Russia's inherent right of self-defense under Article 51 of the UN Charter and relevant customary international law, which no doubt is jus cogens. As has been noted at an earlier stage of this very case, the right to self-defense recognized in Article 51 is inherent in every state and cannot be overridden by any pronouncement that the court may make as to the consistency of Russia's military operation with the Genocide Convention. As a result, whatever decision that the court may render under the Genocide Convention over Ukraine's claims may not have any practical effect on the realities on the ground which have arisen under Article 51 of the UN Charter and customary international law. In addition to Northern Cameroons, the court has also emphasized the importance of ensuring that a judgment be capable of effective application or susceptible of compliance or execution and not wholly an academic exercise. Ukraine prefers not to see this emphasis. Ukraine pinned a Genocide Convention label to the happenings on the ground and continues to cling to such a label for jurisdictional purposes, but its claims betray their true nature. Ukraine's memorial demands the court order Russia terminate the use of force, all shown on the screen for you, which I need not read. Clearly, these are claims arising under Article 51 of the UN Charter and relevant customary international law. Furthermore, as Russia has explained many times and in many fora, which Russia reiterates here, Russia never claimed such rights and never used the Genocide Convention as the basis for its actions. They are based on the right to self-determination and its inherent right to self-defense, also enshrined in Articles 2 and 51 of the UN Charter, and on corresponding customary international law. In light of all this, any judgment that the court may render under the Genocide Convention would not affect existing rights and obligations of the parties, thus removing uncertainty from their legal relations surrounding the special military operation or Russia's recognition of the DPR or LPR, will be capable of effective application or susceptible of compliance or execution. Ukraine attempts to distinguish northern Cameroons on a number of grounds. That attempt fails. First, Ukraine quotes the court's statement that a judgment must have some practical consequences in the sense that it can affect existing legal rights and obligations of the parties, thus removing uncertainty from their legal relations. As already shown above, Russia's legal rights stem from the UN Charter and customary international law, and are thus not capable of being affected by a decision under the Genocide Convention. Furthermore, there is no uncertainty between Russia and Ukraine on the question whether the Genocide Convention provides a basis for armed intervention. Both parties agree that it does not. Ukraine also says that a judgment will establish that Russia has an obligation to perform its obligations under the Convention in good faith. That is also uncontested by Russia. Thus, the court's decision will add nothing of value. Secondly, Ukraine attempts to make a great deal out of aspects of the facts in the Northern Cameroon's case, such as the lapse of the treaty at issue. In fact, the court did see some potential in Cameroon's litigation maneuver, but noted that Cameroon recognized that the court could not invalidate the plebiscite, which was a key event there, and asked the court to address a question of no relevance, which led the court to realize that, as a result, the court is relegated to an issue remote from reality. Furthermore, agreeing that the use of judgment, if rendered in that case, would lie on the political plane, the court responded, "It is not the function of a court merely to provide a basis for political action if no question of actual legal rights is involved." The court then declined the invitation to play there. Here too, in this case, by asking the court to rule on the interpretation and application of the Genocide Convention, Ukraine relegates the court to an issue remote from reality, the reality surrounding the special military operation, so as to provide a basis for Ukraine's political action. Madam President, distinguished judges of the court, I will ask that to this invitation from Ukraine, you say thanks, but no thanks. Ukraine's attempt to distinguish nuclear tests also fails. Ukraine noted that certain type of nuclear tests were stopped in those cases, but that the special military operation is ongoing now. Again, the special military operation is not going along the legal line as Ukraine claims, i.e. under the Genocide Convention. Whatever facts prevail in nuclear tests, the key rule is that at the time of adjudication, there must be a life dispute between the parties for the court to proceed, or as the court said, the dispute brought before it must therefore continue to exist at the time when the court makes its decision. This has been confirmed in the recent judgment in Chile versus Bolivia. Here, there had never been a dispute between the parties under the Genocide Convention to begin with, as Russia never claimed that the convention what Ukraine put in Russia's mouth, which was made clear in Russia's letter to the Security Council before the filing of the application, and affirmed in Russia's letter to the court dated March the 7th, 2022. Quite a few other statements confirm the same point. Ukraine also suggests that reparation for the harm suffered due to Russia's non-compliance would represent practical effect. However, such reparation would be impossible if the alleged harm was due to Russia's exercising its right to self-defense, over which the court has no jurisdiction. And any such right to Ukraine would be overridden by Russia's right of self-defense. Finally, Ukraine attempts to recast Russia's no practical effect objection from an objection on admissibility to a defense on the merit. but this is meritless. Ukraine argues if Russia wishes to deny that the convention played any role in its actions, then Russia is free to present the alternative factual narrative as a defense on the merit. But Russia has demonstrated in its preliminary objections and in the presentations today very clearly that the Genocide Convention plays no role in its military operation, clearly and manifestly. That operation is conducted under the right of self-defense, and this objection of the Russian Federation should be decided at this stage. In sum, any potential judgment upholding Ukraine's claims would be devoid of practical effect, and as a result, these claims are inadmissible. Madam President, I've come to the end of my presentation. I would like to invite you to give the floor to Mr. Udivichenko to continue the presentation.
I thank Professor Yi for his statement, and I now invite Mr. Kirill Dovichenko to take the floor. You have the floor, sir.
Madam President, distinguished members of the Court, it is an honor for me to appear before you today on behalf of the Russian Federation. I will present Russia's fifth and sixth preliminary objections, and I begin by demonstrating that Ukraine cannot present, at least not in this court, a reverse request that there is no evidence of genocide. In its application, Ukraine sought a declaration that no acts of genocide have been committed in Luhansk and Donetsk. In the memorial, Ukraine changes its claim and requests the court to declare that there is no credible evidence that Ukraine is responsible for committing genocide. Russia has already explained why this change is inadmissible. Nevertheless, both the original claims and the new claims are formulated to seek a negative declaration. Thus, none of them can be accepted by the court for this reason alone. The court has before it an unusual situation where a potential wrongdoing state attempts to preempt the orderly process and rushes to the court to get a judgment that there is no breach of its obligations. To request such a reverse compliance declaration is essentially to force the respondent state to litigate a legal claim that it has not made yet. Such reverse requests are a speciality of the WTO law, but their implementation suggests specific provisions that were carefully negotiated in the WTO dispute settlement understanding. Significantly, they allow a panel to assess the legality of measures that a party took to comply with the recommendations issued in a dispute that had been already adjudicated. Such reverse requests are not expressly permitted or even known in international dispute settlement more broadly, and for a good reason. A reverse compliance determination would preempt the right of the state to invoke responsibility of another state if and when it considers appropriate to do so. States that have not breached any obligations might become respondents and would have judgments issued against them. Ukraine attempts to find a basis for its reversed claim in Article 9 of the Genocide Convention, which states that the dispute can be referred to this court at the request of any party thereto. But according to the Travaux Préparatoires, the drafters of the conventions did not attach any specific meaning to this phrase and considered this addition as merely editorial in nature. If we read this phrase properly, its meaning is very simple. Should two contracting parties have divergent views as to the interpretation, application, or fulfillment of the convention, either can then refer this issue to the court. This phrase does not, cannot, and as the Travaux confirms, was never intended to change the standard way of how the states invoke responsibility of each other. For half of the century that Article 9 exists, no one has argued in favour or even suggested such as a distorted reading of this phrase. Besides the fact that reverse compliance claims are alien to the Convention and to the international law in general, there are at least 4 additional reasons why the court should refuse to proceed on Ukraine's request in this case. First, the Genocide Convention does not and was never intended to determine whether a state has made a valid allegation of genocide against another state, let alone whether such allegation is supported by credible evidence. As its title makes it clear, the Genocide Convention concerns only the contracting parties' erga omnes obligation to prevent and punish this heinous crime. In the declaration to the Order on Provisional Measures, Judge Benuna has already exposed a fundamental flaw of Ukraine's claim and noted that it is unclear what right protected by the Convention is allegedly breached in this case. Judge Benuna is right. By advancing a reverse claim, Ukraine does not actually exercise any legal right under the Genocide Convention. Instead, it raises a premature defense against the potential claim of which no one has yet seized this court. Whether or not Ukraine has breached the Convention is a matter for the court to decide if and when such an issue is validly brought under the Convention against Ukraine, not by Ukraine. Thus, Ukraine's reversed request still fails to engage a plausible right under the Convention so that the court could allow that request and actually exercise jurisdiction over this case. Second reason not to proceed with Ukraine's request is that Ukraine's reverse claim contradicts the international law principles of judicial propriety and equality of the parties. Interstate disputes require careful and lengthy preparatory work, especially when they concern serious human rights violations such as genocide. Hundreds of individuals need to be interviewed. Numerous records must be located and studied. Complex experiments need to be held. Years of fact-finding would elapse before an applicant is able to collect evidence worthy of the esteemed court. On the contrary, an applicant under the reverse claim, by contrast, is relieved from this burden. Ukraine attempts to prove a negative fact. It naturally serves Ukraine not to present evidence of genocide to the court, but to conceal it. As the court is well aware, for the past 8 years, Donetsk and Luhansk regions have been suffering from ongoing attacks and other hostilities executed by the forces of the Kyiv regime. This makes any fact-finding work on site very difficult, if not impossible. We all know cases in the past where definitive evidence of genocide transpired several years after it was committed. We should not turn a blind eye on this terrible experience of the belated revelation. Under Article 60 of the statute, the judgment of the court is final and without appeal. It would constitute res judicata. If a state is allowed to secure a preemptive victory against a patently incomplete set of evidence, it would thus have protection against the subsequent claim against it, even on the basis of the new compelled evidence that become available in the future. On the other hand, if the court dismisses Ukraine's claim, the court will not automatically hold Ukraine responsible for the breach of the Genocide Convention. The court will only rule that Ukraine cannot preemptively stop a claim that could be brought against it in the future. Third reason is that engaging with Ukraine's reversed claim is incompatible with the judicial function of the court. Ukraine asks the court to assess the existence of genocide by Ukraine. But this court is not a body that conducts complex investigations, especially those of criminal nature. It does not have a fact-finding mission. The United Nations have tasked this court with settling legal disputes between states. It is not the court's role to gather and assess factual matters on the ground. especially long before a legal dispute has actually materialized. Fourth, the court's own case law speaks against reverse compliance claims. The court has simply refrained from considering them. From almost 200 cases ever brought before the court and its predecessor, Ukraine was only able to find 2 matters which it believes resemble reverse compliance case. These are the Lockerbie proceedings and the rights of national case. But these references are clearly flawed. Judge Shahabuddin warned that the judgment may not be deemed as a convincing precedent when it did not rule on the disputed legal point. This consideration is applicable to the present case. In the cases relied by Ukraine, the reverse nature of the claim was not subject to court's review. I will start with the Lockerbie case between Libya and the United Kingdom, on which Ukraine referred to in its written observations. In that case, Libya asked the court to declare that it had fully complied with all of its obligations under the Montreal Convention, and that the United Kingdom had breached and is continuing to breach its legal obligations to Libya under the Montreal Convention. This case is not compatible with the present one for several reasons. First, in Lockerbie, the United Kingdom did not object against Libya non-violation complaint per se. Unlike the present case, its objections relied only to the existence of dispute between the parties and did not concern admissibility of Libya claim. In fact, the court did not specifically address the United Kingdom's reverse compliance objection and limited itself to stating that the dispute exists between the parties under the Montreal Convention. It would be improper to present the Lockerbie judgment as a case on admissibility of reverse compliance claims, as the court simply refrained from considering such claim. Second, Libya's application on Lockerbie concerned its compliance with specific obligations on cooperation in criminal matters. Libya claimed that it had taken all measures to fulfill its duties under the Montreal Convention. Libya addressed the court with a request to prove a positive fact, that all measures were taken. On the contrary, Ukraine takes the matter much further when seeking a negative finding, that the genocide did not take place. In order to argue that Lockerbie is relevant, Ukraine needed, or at least to argue that it took all reasonable measures to prevent genocide from happening. This, of course, would not make the underlying claim admissible, but the reference to Lockerbie would only then be appropriate. Third, in Lockerbie, Libya only asked the court to issue a declaratory judgment. In contrast, Ukraine raises the stakes and requests various specific remedies. Ukraine has also referred in passum to the rights of national case. Earlier, Russia has already demonstrated why that matter is completely different from this case. First, the rights of nationals did not concern the investigation of crimes, especially of such magnitude as genocide. In that case, France asked the court a question of a purely legal nature: whether certain domestic regulations are consistent with international treaties. This question did not hinge upon the examination of evidence. Second, as in the Lockerbie case, France did not seek any remedies in this regard. In contrast, Ukraine asks the court to award various remedies, including compensation. Third, the rights of national case concerned what was essentially a bilateral matter between two states, whereas this case, the obligations under the Convention are of the erga omnes nature. Fourth and finally, even if one could consider France's application on the rights of national case to be even remotely similar to Ukraine's request in this case, any such resemblance ended when the respondent state, well, in that case the US, chose not to pursue any objections on the jurisdiction or admissibility. Instead, it brought a counterclaim against France. From that moment, the rights of nationals was transformed into a standard contentious case between the two states. As you may see, there are fundamental reasons why the court has never dissented to consider reverse claims in the context of invoking responsibility. Any such judgment would not rest on solid facts, would not be fair, and would only spawn prejudice. Madam President, this concludes my arguments on Russia's fifth preliminary objection. I would now move to the final one. The court's case law acknowledges the existence of inherent limitations to its judicial function. One of such limitations recognized by the court is one party's abuse of process. The court has indicated that if the circumstances so require, it may render application inadmissible and decline to proceed with the case based on the abuse of process doctrine. According to Professor Kolb, abuse of process can be described as the use of procedural instruments with the aim to secure an undue advantage to oneself with the intent to deprive the proceedings of their proper object and purpose or outcome. There could be no doubt, by the virtue of the underlying proceedings, Ukraine attempts to handcuff a state right to self-defense. The right which the Charter describes as unimpairable. The Genocide Convention is used only as a pretext. Even a quick look can reveal this straightforward plan. Ukraine pursues the claim but does not have a dispute under the Convention. Otherwise, it would not have fabricated the only piece of evidence of a so-called dispute just hours before filing this application. Ukraine pursues the claim, but it is different to what was requested at the outset of the proceedings. Ukraine changed its case in the memorial. Its new requests to the court have nothing to do with the allegations of genocide or even absence of genocidal acts in Donbass. Instead, they deal directly with the use of force and recognition of states. Just look how the word genocide disappears from Ukraine's submissions, while the references to the words recognition and use of force significantly multiplied. Ukraine pursues the claim, but cannot explain what right under the Convention was violated. The principle of legal certainty does not allow the claims to be vague and imprecise. Ukraine's memorial tellingly fails to indicate the right envisaged by the Convention that was purportedly breached, even after Judge Benuna directly raised this issue at the provisional measures stage. Therefore, Ukraine seeks an answer from Russia, but has posed no coherent question. And finally, Ukraine pursues its claim with interveners. This twisted case cannot survive on its own. Any manipulation becomes more effective when supported by several actors. So Ukraine rallied its supporters to arrange a massive intervention campaign in an attempt to bend the court to their will. This was done openly, discussed in public, and performed in the most insolent manner. The wording of interventions is copy-pasted from one application to another. Never before the court has seen such a massive intervention campaign, a truly exceptional circumstance, while a rally to arrange such intervention is indeed an abuse. Hence, we observe exceptional circumstances where there are strong reasons for the court to find an abuse of process and declare Ukraine's claims inadmissible. The present case is one where the abuse is so manifest that it should not be overlooked. Madam President, members of the court, that concludes the submissions of the Russian Federation today. I thank you for your attention.
I thank Mr. Udovichenko, whose statement brings this sitting to a close. The oral proceedings in the case will resume at 10 a.m. tomorrow, Tuesday, 19 September, when Ukraine will present its first round of oral argument. The sitting is adjourned.